Liability of paying banker when customer's signature on the check is forged. Section 128. Where the banker on whom a cross check is drawn has paid the same in due course, the banker paying check, and in, in case such check has come to the hands of the payee, the drawer thereof, shall respectively be entitled to the same rights, and be placed in the same position in all respects as they would respectively be entitled to and placed in if the amount of the check has been paid to and received by the true owner thereof. First, when the customer's signature on the check is forged, there is no mandate to the bank to pay, as such a banker is not entitled to debit the customer's account on such forged check. Canara Bank versus Canara Sales Corporation and others, 1987. To Supreme Court cases 666. The company had a current account with the bank which was operated by the company's managing director. The company's accountant in whose custody the checkbook was, forged the signature of the managing director in 42 check totaling 3,26,047.92 over a period of time. This was detected by another accountant. The company immediately on detection of the fraud demanded the amount from the bank. The bank refused payment, and thereof the company filed a suit against the bank. The bank lost the suit and took the matter up to the Supreme Court. The Supreme Court dismissed the appeal of the bank and held that since the relationship between the customer and the bank is that of a creditor and debtor, the bank had no authority to make payment of a check containing a forged signature. The bank would be acting against the law in debiting the customer with the amount of forged check, as there would be no mandate on bank to pay. The Supreme Court pointed out that the document in the check form on which the customer's name as drawer was forged was a merely nullity. The bank would succeed only when it would establish adoption or estoppel. In deciding the case, the Supreme Court relied on its earlier judgment in Beta Cooperative Development and Cane Marketing Union Limited versus Bank of Bihar, AR 1967, Supreme Court 389. Second, in a joint account, if one of the signatures is forged, then there is no mandate and banker cannot make payment. The case law in this case is of Behta Cooperative Development and Cane Marketing Union Limited versus Bank of Bihar. Full stop. The cooperative marketing union had an account with the bank, which was authorized to be operated by joint secretary and treasury of the cooperative marketing union. Full stop. On 16 April 1948, the bank made payment of 11,000 rupees on a loss leave check and not on check, one of them, the signature of a joint secretary was forged. Full stop. The bank made payment whereupon the cooperative marketing union used the bank for recovery of the money. Full stop. Though the bank admitted negligence on its part, it urged that the employees of the cooperative marketing union were dishonest in the discharge of their duties, and as such it cannot succeed. The matter went up to the Supreme Court, and the Supreme Court, while allowing the case of the cooperative marketing union, held that one of the signatures was forged so that there never was any mandate by the customer at all of the banker, and the question of negligence of the customer in between the signature and the presentation of check never arose.